All right. Let's get started. Can you get a thumbs up if you can see the screen that I'm sharing, which should be a PowerPoint slide? Great. Welcome to Preparing Students for the NextGen Bar Exam, incorporating formative assessments into your classroom. This webinar is presented by the AALS Teaching Methods section. I am Jeff Minetti, Assistant Dean for Academic Excellence and Bar Success at Seattle University School of Law. I'm speaking to you from my office today in Seattle, where the sky is gray, but the coffee is hot. My co-host for today is Kelly Gamble. Kelly, would you take a moment and introduce yourself, please?
Hi, I'm Kelly Gamble, Associate Dean for Strategic Initiatives at Willamette University College of Law out in Salem, Oregon. Our sky is pretty blue, but our coffee is still great. So thanks.
Kelly, I love that title, Assistant Dean for Strategic Initiatives. That sounds wonderful. I want to know more about that at some point. Kelly will be monitoring the chat for us today and assisting with the Q&A near the end of the presentation. We have three formative assessment experts on tap today. Panelists, I'd love for you to each introduce yourselves to the group. In addition to your school and the courses and students you teach, please also tell us when your jurisdiction plans to adopt or first administer the NextGen Bar Exam. Jennifer, you want to get us started?
Sure. My name is Jennifer Gregg, and I'm the Assistant Director of Academic Success at Ohio Northern University. I teach a first-year lab class, a legal problem-solving and analysis, advanced legal analysis, as well as I've co-taught domestic relations with Melissa Kidder. We are here in Ohio, and Ohio has not said yet when they're going to the NextGen Bar or if they're going to the NextGen Bar. But our students here go to a variety of different states: Indiana, Pennsylvania, West Virginia, Michigan, Kentucky, and some of those states are adapting pretty quickly. So we are preparing those students as well. Thank you.
Yeah, thank you. And Melissa, please introduce yourself to the group.
Thanks, Jeff, and thanks, Jennifer. My name is Melissa Kidder. I am the Director of Law Clinics and Externships here at Ohio Northern University and an Associate Professor of Law. Along with co-teaching domestic relations with Jennifer, I have taught a number of skills classes in addition to running our clinic and externship course classes, such as pretrial litigation and client counseling. I've also taught juvenile law and again, domestic relations. As Jennifer said, we're not sure when Ohio is going to adopt the NextGen Bar, but it is an important thing for us to be able to prepare our students. And I have deeply held beliefs about incorporating experiential learning opportunities in all of our courses in legal education. So I'm really excited to be here. Thanks.
Thank you. I appreciate y'all's presence here. Looks like Megan is joining us. Aha, there she is. Megan, just in time. We are working through introductions. When you're ready, please introduce yourself. Tell us a little bit about where you are, who you teach, what you teach, and maybe when your jurisdiction plans to first administer the NextGen Bar Exam.
I'm in Florida at Nova Southeastern. Thanks for inviting me. And we are going to be adopting the NextGen Bar in 2028 is what I last heard, which was a shock to most of the Florida law schools because no one thought the Florida bar would do that. And I teach advocacy courses and experiential learning, but my expertise is mostly in criminal law and criminal procedure, evidence, and that kind of stuff.
Well, from those introductions, you can see that we've got three great folks to talk with us about formative assessments that are designed to help students prepare for the NextGen Bar Exam. We've got a relatively simple roadmap ahead of us today. I'm going to briefly summarize some of the content, scope, and assessment formats for the NextGen Bar Exam, really just to set a context for the conversation that will follow. Then each of the panelists will take a few minutes to share about how they have gone about thinking about the NextGen exam, thinking about teaching students and assessing students around the skills and content that'll be assessed on that exam. I will reserve about 10 minutes or so for questions and answers at the end. That said, if you've got a burning question for a panelist as that person is talking, as I mentioned a moment ago, Kelly will be monitoring the queue and potentially be able to interrupt a panelist and ask a question that you've got to get stated quickly. So with that, I think we'll get started with our NextGen overview. So this map reflects, as of last week, the jurisdictions that have adopted the NextGen Bar Exam. Just this week, recent adopters include North Dakota and West Virginia, who both indicated an intent to adopt the exam in 2027. I think that number of 25 jurisdictions is correct. Those are the states that have indicated intent to adopt the exam. Kelly and Oregon, and myself in Washington are among 6 jurisdictions that are going to administer the exam for the first time in July of 2026. So our 2L, second year students right now will be taking that exam, and a lot of our programming is geared toward helping those students prepare. With respect to the exam content, this is a slide that NCBE put together that basically summarizes how it is approaching the NextGen Bar Exam. And what I hope you take away from this slide most significantly is the integration, the marriage between content and skills. That is the primary thrust of this NextGen exam. The idea is to create a bar exam that does a better job of really assessing competency to practice law with an emphasis on the practice side. So we have fewer substantive topics. You can see the list there of 8 or 9. And then we have this set of skills that have been clustered around groups A through D. And those skills will be assessed in a variety of formats, from multiple choice to integrated questions and performance tasks. I'll have more to say about that in a moment. In addition to the doctrinal areas listed here, the NCBE has signaled that trusts and estates will be a part of each administration of the NextGen exam starting in July 26, going through February 28. It'll be assessed either through a performance task or an integrated question set with legal materials provided to the graduates. So just know that while trusts and estates is not mentioned here, it is a topic that will be assessed through the exam. Kelly, if you could drop into the chat the content scope, at least as we have it so far, that would be great. If you have more question or concern about the content scope of the NextGen Bar exam, this link will get you more information about it. Next, I simply want to really just highlight the question formats that will be used in the exam because they are different. The NextGen exam, rather than being a 2-day exam where one is focused on written work product and the other multiple choice, NextGen is a 1.5-day exam that'll have students cycling through layers of questions. And you can see the diagram in this slide, again, provided by the NCBE, that summarizes how each 3-hour block will work. It'll include multiple choice questions, an integrated question set, more multiple choice, integrated question set, and the performance task. Just a few words about each question type. Of course, there will continue to be standalone multiple choice questions on the exam. They will appear by themselves for a number of questions. We don't know exactly how many yet. They will also appear among the integrated question sets, and a few may also appear in legal research-oriented performance tasks. So multiple choice questions will still be a significant part of the NextGen exam. The questions will initially look a lot like the current MBE, multi-state bar exam questions, in that they'll have a fact pattern and 4 answer choices. But the NCBE is telling us that the questions will revise into up to 6 answer choices with single select and multiple select correct answers as part of the questions formats. The next set of assessments will be integrated question sets. And what we know so far is that there'll be 6 integrated question sets, each taking applicants around 24 minutes to complete. Those integrated question sets will either be structured as counseling sets or drafting sets. With the counseling sets, there'll be a client-focused scenario where facts are delivered to the examinee in a format that is more associated with practice than it is a traditional law school sort of fact pattern. The examinees will be asked a variety of questions, short answer questions, and also multiple choice questions. And those short answer questions will be very short answer, a sentence or 2 in response to the questions. In the drafting set integrated questions, examinees will again be given a fact pattern through plausible law practice-oriented documents, a client-focused scenario, and then the examinees will be invited to revise or edit a document, perhaps a complaint, perhaps a contract. Again, 6 sets total for a total of 20, taking 24 minutes each and about 27% of the examinee's total score. Last question format are performance tasks. And this item is going to be similar to the current multi-state performance task. There'll be a closed universe file that includes facts that the students are going to need to respond to, a library of legal authority, and then the students will be assessing skills. The tasks will assess skills in legal research and written legal analysis. Across the three-hour blocks, there'll be 3 performance tasks, each taking approximately 60 minutes for approximately 33% of the total score. All right, so with that very brief overview of the NextGen Bar Exam, I'm going to stop sharing my screen in just a moment and invite our panelists to talk about what they're doing with what we know about the NextGen Bar Exam so far. Jennifer, you want to get us started?
Sure, let me just share my screen here. So I have been tasked, can everyone see that? I have been tasked today to talk to you really about integrated question sets that we have done. As we know, the new NextGen Bar is going to be integrated question sets along with these MBE style. The NCBE has described these integrated question sets as just under a quarter of the exam time will be devoted to them. Each of these sets is based on a common fact scenario and may include some legal resources, excerpts of statutes or judicial opinions, and or supplemented documents, police reports, or excerpts from a deposition, and will include, again, multiple choice questions and short answer questions. So you can get 2 samples of these integrated question sets right from the NCBE website. So if you want to click on the QR code or the link, that will take you there. And again, these PowerPoints will be available to you after today, so you can follow that QR code. So some of the sample integrated question sets from the NCBE are these drafting or the counseling. So this one that I have shown you here is one of the drafting ones. You get a little snippet. You're an associate at a law firm. Your supervisor has asked you how to work on a case. You get an excerpt of a supervisor email, an excerpt of a transcript, an excerpt of a rule, and then an excerpt of the complaint. The assignment is then follow the instructions in the email from your supervisor, find 5 mistakes in the complaint. For each mistake, identify the paragraph and the mistake. The counseling integrated question sets are similar to this, where it gives you an initial interview, a month-to-month lease, a statute on a landlord's duty to maintain premises, then questions on the applications of the statutes, excerpts from an email, and the task is considering your client's objective and applicable statute, describe 2 other potential risks of filing a claim or claims of the client's behalf. So observations from the pilot testing of these is that students don't know how to attack multiple choice questions with multiple answers. Some of these multiple choice questions are going to have 6 responses and you have to select 2, and the students just really don't know how to attack those. The students do not like getting their information in pieces in the integrated question sets. And then also that critical reading and short-term memory are going to be key to this exam. So why use integrated question sets as your formative assessment? I understand that a lot of professors don't want to teach to the test, but I see these integrated question sets more as what you get as a new associate. You get the information in small lumps. You get a client intake from your senior associate or an email from your senior associate. Then you interview the client. Then you get opposing pleadings from the opposing counsel. That's how these integrated question sets are formatted and how we need to teach our students how to think like an attorney. Most of these integrated question sets are set up for real-world skills, not just bar exam skills. Reviewing documents such as complaints, leases, statutes in the 1L year is really important. And as an attorney, these are the documents that they're going to be looking at. So incorporating these into your 1L classes, not just teaching to the test, it's teaching skills that these students are going to need. The integrated question sets and the PTs are going to put the students in the place of the attorney, not in the place of the judge. What would you do if this was your client, or how would you respond to your client? So a lot of times you can just rephrase the current questions that you have to put the student in that position of the attorney. These are real world skills that we tend to assume students can transition into from our classroom. But today's Gen Z students are having a problem adapting. So using these types of questions in your classroom will help them get accustomed. So Melissa and I have presented or have developed some of these integrated question sets through the Access Lex Institute's Building Bar Skills modules. And you can follow this QR code and go to Access Lex, and you can ask them for these modules. They have several modules for several different subjects. Melissa and I worked on torts, and we did 2 integrated question sets and a performance test. The integrated question sets were based on a rule synthesis set and a negligence set. The first module gives the students a client intake form and a short scenarios, and then asks them basic questions. What issues does the client have here? That gets you into that issue spotting. Eventually, we narrow it down into a single issue and ultimately complete a rule synthesis on one of the elements. I believe it's on IIED. The second integrated question set that we developed starts with a police report, a short set of facts that then moves directly into issue spotting. If the client was coming into your office, what issues do they need to discuss? What statutes do you need to review? We give them a statute. We have them review that statute right there. Is this a contributory negligence or a comparative negligence state? We kind of walk them through the elements, bring in negligence per se, racist of a loquitur, and then we ask them next gen questions like, we give them a list of documents. Which of these documents would be relevant? Which would be irrelevant? We give them a list of facts, ask them to categorize the facts as important or not important. Again, getting them to think like they're an attorney and what they would need to do as an actual attorney. Both of these integrated question sets do have a longer writing assessment at the end that you can use or not use. And by using this, I was able to tell very shortly after that what my students have learned, if they understand IAED, if they understand negligence. Do I need to go over this more in class? Do I need to pull some of them into a smaller group and work with just a small group of the students? I knew that my students were just developing these skills, so they didn't need to be proficient on it, but they do need to start working on them. I did these in academic support classes, an academic support class that was attached to a torts class, so it was based on torts. Just a little bit about how I developed these. When I developed them, I looked at what I thought the students should know or be working on at this point in their education. I was giving these assessments in their first semester. The rule synthesis one was just a couple weeks into the semester. So what could I start testing them on? What skills from that content scope of the NextGen Bar Exam I wanted the students to be developing. I knew that a lot of these skills they wouldn't develop in their doctrinal classes, like identify the strengths and weaknesses of the client's position or an opposing party's position based on relevant legal rules and standards. In a matter that requires additional factual development, identify which facts need to be investigated. These come right from the content scope of the NextGen Bar Exam, so I wanted to start inserting this in a skills type class or in their academic success class. Again, I thought it was important to make sure that this was coming from the student's perspective as you are the attorney, because that's how the NextGen Bar Exam is going to be. And just kind of, I think that this is something that you can easily transition your old exams into by changing it a little bit, giving them a little bit of information, asking them directed questions, adding a multiple choice question in that has 6 answers. The NCBE has told us that multiple choice questions that have 6 responses and you have to pick 2, they will be giving partial credit if you pick 1 correct, but not the other one correct. So just starting to set the students up in their first year on building on these skills that will help them not only in the NextGen Bar Exam, but will help them as an attorney. So that's how I kind of started this. and went into this with that point of view. So I don't know if anyone has any questions, or we can go right into Melissa next.
Yeah, I've got one question came out while you were speaking, Jennifer, and that was when you described that the applicants would get the information in pieces, you sort of summarized that with the TORC module that you had developed, but can you tell us more about how facts will be delivered to examinees on the NextGen Bar exam and how you are going about replicating that in the formative assessments you're creating?
Yeah, so unlike our current exam test or the current MEEs where you get that block of 1 page of facts and then you have to answer questions, the integrated question sets are going to give you like a police report and then ask you questions about it. What do you see from this police report? And then they'll give you a snippet from, okay, well, now you have this email from your superior attorney who has talked with the client, and this is the information they have given to you. And so the students have to build on the information that they learned in the police report, add it to the information that they have now from this attorney email, and answer more questions about it. My understanding from the NCBE is that the students will be able to scroll back up and see previous information. But again, as we know, that's going to take them time that they just don't have on the exam. So it'll be important that they have that critical reading and those short-term memory skills, that they can go through these question sets, get information, answer questions, add additional information on that same topic, and then answer new questions, incorporating the original information and the additional information.
Appreciate that response. And also really appreciate the thrust of your comments, which is about this is an exam that is designed to really assess competency to practice in a more direct way. And that rather than thinking about into a test, if professors will just focus on teaching to practice, they're going to accomplish many of the objectives of the exam. Thanks for your comments, Jennifer. There are a few other questions in the Q&A that are more directed at the NextGen Bar exam generally. We'll address those when we reach the Q&A session toward the end of the hour. Melissa, if you could please tell us about your formative assessments.
Absolutely. Let me go ahead and share my screen. Should be there. Okay, great. Well, thank you again for the opportunity to chat with all of you about formative assessments. I forgot to mention in the beginning of my introduction, along with doing the externships and clinics, I have a deep love for assessments. I've been the chair of our law assessment committee for a number of years, and I'm also on the university assessment committee. And so when I approach assessments, I look at it from a standpoint of a lawyer, but then also a teacher in teaching, future lawyers, and then from, an assessment perspective, which I'll talk about in a little bit about how I created some of these other assessments in that hat and role as well. So to kind of piggyback off of what Jennifer was saying, when we were developing these modules with the Access Lex grant, one of the things that I focused on was integrating the modules with a performance test. And at the time we were designing these, the performance tests were designed more at the, for the bar exam to be 90 minutes, a little bit of a longer, process. And so this performance test that I created was a little bit more in depth than I think the NCB has shifted to, which are more 60-minute type of, the expectation is that they'll get through 60 minutes. But I still think it was important to introduce students, especially in their first year, to some of these basic skills, because they will see it in some way when they get to the bar exam. So when we talk about a performance test, we're talking about this as, a closed universe. This particular module was created with several components because it was designed for first years who had maybe never had seen a performance test before. So there was a series of guided questions and then a self-reflection at the end. There were two main objectives: to introduce them to critical bar exam assessment, but then also for the students to have an opportunity to demonstrate on a basic level some, key legal research and writing skills that they would likely have to do as a first-year associate. Skimming through 3 cases in a statute and then giving an opinion to a client or an associate or a partner in a law firm. I picked the topic of a strict liability dog bite statute because it was a clear strict liability statute that was simple, that there were 3 cases that the students could reference, and then analyze and give an opinion to the attorney in their law firm or client that they were representing. And the timing of this was more about like the middle or the end of the semester. I think giving the students a performance test probably at the start might overwhelm them a little bit. So this was building on the modules that Jennifer and I had created with the integrated question set. So the PT itself was, you had a client file, you had a memo from the partner, and a snippet of a client interview with a transcript. It had a statute and references to 3 cases, and then the task was to write an opinion to the client. And so this was an example of some of the guided questions. The guided questions were designed in a way so that the students would walk through the whole thing together if they'd never seen one before, and ask them a series of questions so that then by the time they were done with the guided questions, they could perform the task that was asked of them, which was to write an opinion letter to the client. And they could use all that information that they had built up with the question sets previously to then do the task. And then once they were done with the task, they would be able to reflect looking at a model answer as to how they did on it. Now, we designed these modules so that the professors didn't necessarily have to take up class time to do it. They could give it to them outside of class. The guides were designed in a way that could be integrated into an LMS, or the professors could do it in class if they wanted to walk through it with them. They could assign it in pieces. They could assign just the task itself of writing the opinion letter without the guided questions. They could, give them feedback on their with the model answer, or they could ask the students to do it outside of class, looking at the model answers. So there was a lot of variety that somebody who was unfamiliar with it could pick and choose. And I did that in a way because we all have our own ways of teaching classes, and I wanted to make it as flexible as possible. To be clear, these were not designed, and I don't think we're talking about today, things that are summative assessments. These are not things that are supposed to take the place of your final exam where the students get a major portion of their grade at the end of the semester. These are simply designed to give students opportunities to think about how they would put this in the context of the class you're teaching in a lawyering skill. That, we hope will mimic what will be tested on the bar exam. But as Jennifer was mentioning, also will be important for them as a lawyer. But these are not designed to be like graded at final exam, summative assessments. In fact, for the most part, while you may put a grade to them for completion purposes, they're designed to the students can have feedback on how they're doing in that topic or in that skill. And so as it relates to these, they're not designed to be, I don't expect a student in the first year to be proficient in these things. I don't expect them to be an expert. I just want them to be introduced to it so that they can start thinking, okay, well, I did well in this component. How do I do well going forward? And then continuing to, work on more assessments. So I wanted to make that clear that these are not supposed to be, designed to take over your exam. And, we designed them to be things that would be able to be used in a variety of different ways. So with respect to the externships and clinics, I have looked at this from a similar perspective, but more on my hat as like in the outcomes and assessments chair of the law school and as the university representative for our university committee. And I do that because, we are in a regional area where we have accreditation standards where we have to meet, certain accrediting body standards. And some of those from the Department of Ed are higher, our particular region accreditor is the Higher Learning Commission. And so we have to show certain things as an institution at Ohio Northern to meet our accrediting standards. And so some of that comes for, the programs all demonstrating that they have learning outcomes, as we all do now, and that our programs and our students are able to meet those outcomes. And so we do that by giving students assessments and, gathering the data on the assessments and then being able to report that data back to an overall program assessment to the university. And all of our programs have to make a report to the university every year, at least on 3 of our outcomes. And so for me, when I was asked to, provide write these reports to the university, I did so for all our outcomes, but as an externship and clinic director, I was particularly concerned about the lawyering skill outcomes, the ones that, how do I show that our students are meeting research skills and writing skills and counseling skills and things like that. So I designed assessments with rubrics that would be able to be given to students from the professor, but more used globally to an overall accrediting body report to determine whether or not our students were meeting learning outcomes on lawyering skills. And so I did these rubrics in all of our outcomes. And so when I designed, and so these are some examples. I did a Google form so that the professors could just put it in. This was the hard copy of it as well, where the professor, and I let the professors pick. I just asked the professor in the courses, hey, pick one thing that you do, give your students, assess your students on this particular outcome, and then you can give them the feedback, but I need the data so I can report it to the university. And I did it, I kept it pretty simple. I just kept it on a score of 1, 2, and 3. How did the students do? Did they, do, better, good, better, best? And then I would be able to have that data, not only to give to the student about how they were doing overall, but then also for the university. And so some of the things then that I had done in my externships and clinics so that I can report this information to the university are more global. I mean, all my students in externships and clinics do a variety of different lawyering skills, right? At the clinic, that's really what we're doing every day. I needed it to be in a way that was more objectively uniform, where I could give all my students one opportunity to do something that was pretty similar, and then I could give them feedback on it. And how I did that was through a mid-semester meeting. I would have the students where we talk about our semester evaluations, how I thought they were doing individually in their coursework, or with their clients, or their supervisors thought they were doing at the placement. I would ask them to do some kind of assignment for me where I would give them feedback on a lawyering skill. And I did it through, I've done it through a variety of different methods. I've asked them to write a demand letter. I've asked them to write a letter to their client. I've asked them to write an email memo to the partner. And then I've asked them to do a settlement negotiations, like internal memo, like watch this settlement discussion. I can't be there. I need you to tell me what happened and, report back to me what the settlement offer was at the end of the day. And these weren't designed to be like hard in some ways, and I kept them pretty short. So the instructions were generally only like a page, if less than a page. They usually asked them to do like a very small thing, like look at this one type of law, or knowing what you did, just tell me what you thought you heard, or write the demand based on what our client wants. But then I would use the rubric that I had created to then be able to give them feedback on their lawyering skills. And in a way that, kind of gave them everybody on the even playing field, because as we all know, everybody is different. And it was, again, a way for there to be some more uniformity, because I may have a student working on a custody issue. I may have a student working on, you know, an abuse, dependency, neglect. But if they all had to write a demand letter, then I could say, you know, uniformly at individual meetings, hey, you know, your tone was really good here, but you may need to be a little more specific. I could do that individually through all the cases and the situations they brought to me, but this at least got an opportunity to kind of give them more feedback on a global lawyering skill. Again, it wasn't graded. It was portions of the overall assignment completion, but it was just an opportunity to do formative feedback that was more in a controlled environment. And so this is an example of one of the tasks that I've done in my clinic with my clinics and externship students, where I've asked them to watch this short video of two lawyers engaging in a settlement negotiations. And again, it's stuff that we would do in practice. We would report back to the partner what we thought we heard so that we could put it in a memo in case there were any disputes that come up later on, right? And so I just said, watch this short 10-minute video and then tell me in a brief description what happened and, you know, what was the offer at the end of the day so that we could put it in the file. I didn't ask them to assess whether they thought it was a good idea or not, because that's a different lawyering skill. I just wanted them to tell me what happened so that I could then look at their memos and then give them some feedback. So that is an overview of the things that I've done in my courses.
What a wonderfully thoughtful approach to outcomes, to assessment in a doctrinal course, but especially in clinics and externships. I have a question for you, Melissa, but I think I'll hold it for the Q&A, and it concerns self-assessment. For me, one of the challenges I've had is helping students develop a practice and expertise, frankly, in self-assessment. So I'll come back to you to hopefully hear more on that topic later. Right now, let's turn to Megan. Megan, let's hear what you have to say.
Hi, I'm just gonna share right now, and then what I need to know is it sharing the PowerPoints or the slideshow? Do you know what I'm talking about?
Yeah, just seeing the slideshow. Yeah, if you click begin show, I think we'll be good. Yep.
Slideshow or PowerPoint?
PowerPoints, we can see it as we should right now.
Okay, that's all that's always my big thing because I have two screens and I never have any idea where they're at. All right, so I think what I'm talking about is a little bit more macro, and it's in the audience that I'm speaking to is who I was when I started trying to build these modules. I'm looking at it from the perspective of somebody who's actually teaching the 1L class and is being told, hey, you need to incorporate some of these teaching methods. You need to start thinking about, we're not teaching to the test, but we need to begin to think about the next gen in that 1L class. And I think you're already doing that. It's not really a paradigm shift, and it's not, we're not doing anything different, actually. The NextGen Bar is, they keep saying real world types of legal problems. They're trying to test more practice skills. Well, we are doing that. The 1L teaching is for practice because we're learning all of these foundational skills. And now we just need to be more formalized and thoughtful about how we're testing legal research or how we're teaching legal writing and issue spotting and analysis and investigation, evaluation, client counseling, these kinds of things in the way that we teach. Because all they're doing is changing how this performance test. They're just doing these new integrated tests, these new performance tests, but we're still teaching this way. So now how are we teaching this way, 1L professors? Like, how are we okay? Like, we know that we need to begin this skill in 1L year. Are we doing it? Yes. Now we just need to start thinking about engaging with more experiential learning as early as the 1L year. When my module builders and Carletto and Toledo, she was the academic support person. I was the professor who had no experience in academic support. We wanted to figure out how to build things that could be just dropped into a 1L class, where they could just take this off and just drop it into a 1L class. So I have two examples. I have the macro and the micro. The macro is module in a box. It reduces cognitive load. It's not going to take a lot of time. We're trying to make it as easy as possible. And this is just about how you change the way you're testing. You were already going to offer probably a midterm, a final exam. Let's talk about a midterm. You're already doing the midterm. So instead of doing the here's my fact pattern, all these facts, and then you're supposed to highlight and extract those issues, spot the issues. Now you're just adding in a little bit more investigation and evaluation. So now just write it a little differently, right? So write it as this memorandum, our law firm needs to do X, Y, and Z, we're investigating something, and then add pieces. So instead of putting your facts right there in, he was found in a boat and he was dead and here's what happened, you always put that right into the fact pattern. Just do this instead. Put it into an article, right? And then add an arrest report. Or if you're in, you're trying to figure out intentional torts, just an incident report, somebody who took an incident report, and then maybe put in the actual statutes or create your own statutes, but just a section of statutes. With the one that we created, we said, here are the major homicide statutes in this jurisdiction, and we don't practice this kind of law, but we're thinking about taking this case on pro bono. So, oh my gosh, what do you think we have here? Now, if you're thinking to yourself, that's a heck of a lot of work, it really isn't. AI now you can now plug a bunch of facts into AI and say, turn these facts into a newspaper article, put these facts into an incident report, and it will spit it out, and then you edit. So AI can help you. You're still asking the same questions you were going to ask in your midterm. All you're just trying to say, anticipate all the potential torts, tell me any possible homicide charges. You're still asking for the same thing, but you're going to ask it a little differently, and you're forcing the students to have to do the investigation and pick out those facts in a different way, which is more akin to practice, since our clients don't just come, we usually get these pieces of paper that we need to investigate with. So, and then you add another question, ask what you wanted to ask a little differently. So I want to know about affirmative defenses or mitigating factors in homicide. The way I fashioned the memo was, we're trying to take on this client. We haven't met him yet. Here, what are based on what you're reading, what were the potential homicide charges? And then I say, what else would you want that interviewing attorney to ask the client that would basically elicit facts for affirmative defenses or mitigation in these homicide charges? Now you're making them jump through a little bit of a deeper hoop. I'm sorry. They need to come up with self-defense. They need to come up with insanity, but it's how you would ask those questions, what kind of research you'd want to do. So now you're digging into the next gen skill of client counseling, client advising. So that's one example where you're already doing this. It is your midterm. Just tweak it. Just do it a little differently. And then the question becomes, okay, so what are we doing in class to prepare people differently? Honestly, you're already doing it, right? So we have the traditional method, but most of us are moving a little bit away from that. But we would have our traditional brief and read. So all we need to do now is make that book come alive a little bit more and invite more engaged practice. The more they are applying the law, having to draft something from scratch with each other, the more they're starting to think about the skills that are going to be necessary for them to or comfortable for them on the performance and the integrated question test. Okay, so let me give you an example. And this example will be specific to criminal law, but I think it really translates. I think in any 1L class you can do this. So just by way of background, all right, criminal law has to start with why criminal law and how statutes are constructed for clarity. And we, chapter 3, we're going to talk about constitutional limitations to criminal law. We talk about, void for vagueness and due process. And then we move into chapter 4, where we're starting to talk about the component parts of a crime. You remember this, actus reus, the willful muscular contraction. And then we talk about omissions, where the law actually creates a legal duty, either through statute or a special relationship, where you actually have to act. And this is confusing because the law doesn't, as a matter of public policy, criminal law tends to not make you do things. It usually prevents you from doing things like don't murder, don't rape. But these kinds of laws are a little different. So we finish that up, right? And we're at the end of that unit. So how am I going to make them dance and think like a next gen lawyer? I give them this. It's this horrible guy. I like it that everyone Googles him at the same time every year because he exists. But this guy, David Cash, he's just a real bad dude. He was with his friend, Jeremy, and Jeremy pulled this poor girl in a casino into a bathroom and raped and murdered her. I teach criminal law. I'm sorry about that. I should have probably given you a trigger warning. It's horrible. But David Cash walks into the bathroom. He looks over the stall and he sees what his friend's doing and he walks out and he doesn't do anything. And the many, many weeks pass before they figure out what had happened. And all the time David Cash knew. So everybody hates David Cash and everyone wants to rescue this child. And so I say to the students, okay, we'll create a statute that would have created a legal duty that would have worked to penalize David Cash for his behavior in that casino in 1997. Okay, so I'm telling them to do something from scratch. Now, talk about the cognitive load, the work effort, right? I will divide them into groups because now you're forcing them to have the conversation with each other. You're actually forcing them to review and to engage and do the kinds of things that lawyers do, which is listen and communicate. Canvas, any one of your learning support platforms will divide your kids into groups like that with a push of a button, and it gives you a place to upload the assignment. One assignment per group. Again, you're forcing them to talk, then you get their really, really bad statutes, super bad statutes, like really, really bad. And that's fun because then it doesn't take any amount of work for you. You're gonna add 15 minutes of to your class day, and maybe your prep work is done for you. They've done the work. All you do is pop the statutes onto their PowerPoint and then go through them. And it's fun to do that because, what is this? If you look on the screen here, the witness has a duty to report any questionable activity. What does that even mean, right? And then we talk about, while we go through their atrocious statutes and they laugh about them, we are reviewing. We're reviewing the constitutional limitations to the law, or how they scoop up innocent conduct. We're talking about the public policy, about how hard it is to create a statute that makes somebody do something. And you've made them do it. I will bring up the statute that was actually enacted in Nevada that tried to get at his behavior, and we'll compare and contrast this statute that was written to what they did, right? So now we're talking about statutory construction and how they could do a better job. They had to struggle. They had to start with nothing and work with their friends with all of these new principles in mind, these constitutional limitations and public policy ideas, to do something that the next gen is going to be asking them to do comfortably in the next 2.5 years, which is start with a blank piece of paper and write something, right? And create something or investigate something or pick through something. And so this is a tiny thing that I do in my class that is starting to get them comfortable with that skill, with a performance test, with a next gen skill. That's just an example. I am positive that you, in your own 1L class towards Civ Pro, you have a mazillion ways that you can do this, contracts you can show them, things that they can construct exactly like this, where it's a tiny little moment, but you're making them dance. And so that's what I got.
Megan, how wonderful. Your students are fortunate to have you, and you've inspired me to think creatively about how I teach criminal law in the summer. Thank you for that. So we're going to transition to our Q&A. And to get us started with that, I want to go back to Melissa with my self-assessment question, but I have a very quick question for all the panelists. Then Kelly's been monitoring the Q&A and the chat, and she'll signal some other questions for the panelists to address. So Melissa, first, I love that the Access modules make a priority to help students work through self-assessment. And my question for you is, what do you find is the struggle there? How do you best help students get equipped with the skills necessary to effectively self-assess their own work?
Oh, that's not a hard question whatsoever, Jeff.
That might be a webinar all by itself.
I know. I mean, Jennifer will totally agree, even if she won't say it. I love reflections. I love self-reflections. I think it's an important skill that we need to teach our students, because as a lawyer, I think you have to have this ability to do something and then ask yourself, hey, if that didn't go well, like, what would I do to be different? And how would I have approached that client interview in a way that it could have been more successful, or I could have gotten a better result, right? And it's not that everything is, terrible. It's just that we're always trying to think about what could we do better next time. And so that's a hard skill to teach students, on top of having them to teach, the doctrinal, thinking like a lawyer, reading the cases. And so I think that it is something that if we don't start at the beginning, then they come into the door, it's a harder thing to do the longer we delay it. And so for me, self-assessment, especially with the like PT module, I think it's important to just start it and ask them. And we all designed the self-reflections to be similar in our module, in our team modules that year, because we wanted them to pick, even if they picked, you know, a crim law one or a contracts one, the self-assessment was asking the students to do the same thing, because repetition is ultimately the thing that will get them to be better at it. And I don't expect them to understand what they may have done wrong initially out the door, but just forcing them to have to look at their material, compare it to something else, you know, highlight the rule, highlight the analysis, will get them to then start building on the blocks as they get later. So I just think asking them to do some self-assessment, and then I give them, I didn't in the modules because it's hard to do, it's individual, but I would give the students feedback on how they didn't. I was less concerned about how they did on the task and more concerned about how they did on the self-reflection. Because if they can identify what they did wrong and what they did well, then that makes their next task even easier. And so that's where I look at it. And I have like done rubrics where I've said, you know, and again, on a scale of 1, 2, and 3, you've done you're a 2 on this category for reflections, but you're needing to do this on other reflections. So that's kind of how I approach it.
Again, wonderfully thoughtful. Thank you for that. Hold on, my second question. Kelly, do you have some questions from the queue that you'd like to raise?
Sure, we have a few questions that might be really for NCBE or Access Lex, but I think the panel might be able to crowdsource some answers. Is it true that there are 2 types of questions, just standard multiple choice and 6 choices pick 2, or could there be other configurations?
So my understanding from the NCB is that the multiple choice questions will either be one that has 4 answers and you have to pick 1, or one that has 6 answers and you have to pick 2. And those are the only 2 options. That's my understanding from what we've heard from the NCB.
And when family law gets added, is it going to be treated the same as all the other subjects, or will it be handled differently?
So again, and this is my understanding from the academic support community, is that for the next 2 years, family law, wills, trusts, and estates, and secure transactions will be tested in either a performance type test or in an integrated question set where they will give you the law that you need. In 2028, family law comes back in as a subject like criminal law or business organizations is now, where you will have that context scope. The context scope will tell you these are the laws that you need to learn. These are the laws that you just need to understand, as is the content scope for the rest of them. And the NCBE is currently working on that family law content scope for 2028. So once 2028 comes, family law will be like the constitutional law, torts, everything that is in the NextGen now.
Okay, and what about, do we have any sense that the NCBE says, yes, the Access Lex modules are representative of what students will see on the NextGen Bar Exam?
I guess I'll go again. No, we were tasked by Access Lex to prepare these modules. We looked at the modules that the NCBE had already given, and we tried to do ours similar to what the NCBE did, but it is not NCBE sponsored at all.
Yeah, and that kind of was one of the things when I did the PT, you know, I did it designing based on the old performance tests, which were more 90 minutes. And so then when I was done drafting my module for the 3, then the 60 minutes came out, and I was like, well, it's not bad. I mean, it's still a good exercise for them to do. It's just probably more in depth than what they would have to do in 60 minutes. So it definitely wasn't sponsored, but we drafted those in the mindset of looking at what was out there in the public at the time.
Does anyone know when we might get more actual questions from the NCBE? That's everybody's favorite question, I think.
That's a great question.
It is. You know, and I don't know if there's anybody from the NCB on the call, but I know Judy Gunderson was at the ABA Dean's Conference here in Seattle this summer, and I was on a panel with her, and the question came up about more questions. And the answer then in July was that a full 3-hour block of questions would be released in mid-August. Nothing has been released as far as I'm aware, but I think that is the next goal for NCBE, is to release a 3-hour block so that we can see how students will be expected to cycle through those different types of question formats. But I have heard nothing since then.
Melissa, I think you talked about this in your presentation, but in terms of trying to stagger that introduction, the introduction of facts, would you suggest that's primarily a formative assessment, or can you do that in a summative assessment?
In terms of the staggering of facts, I think, Megan, you probably do some of in yours, with your summative, with the more midterm kind of thing.
Yeah, I mean, I think 100% the final exam it can be the same way. It's not, we're already doing this. We've just never unpacked the facts from the piece of paper. You know, we always just give them a big essay. We've never tried to unpack it and just say to them, you find the facts. You just have to take into consideration that it's going to take them a tiny bit more time. So you have to put that into your head, but they're looking for the same thing. They're just not looking for it on a piece of paper. So and when you say staggering facts, am I getting to that correctly or no?
I think that's right. Or I think it's in some sense, making facts available after, that how do they get new facts, but they can still access what their previous questions were? How do you manage that?
Like adding facts.
Right. So,
I mean, with that, I think I saw in the questions that you want to change your previous answer, but you just, that's the whole point, right? That you don't, that when you get every time you get a new fact, it changes the answer. So it's okay for the student to say, well, if now that I know X, I don't think Y anymore. Now I'm going in this direction. There's nothing wrong with an answer that looks like that, because it shows that the student is dynamic and is able to change what they think based on the facts that they get. So I don't have a problem with that. Now, of course, in a multiple choice question, I don't know how they're going to do it. Like if you don't have one fact and so the answer multiple choice is X, and then you get new facts and it would have changed the first answer. Well, I mean, you obviously it's going to cause people to go a little nuts and want to go back and change things, but I think it's much more controlled in an exam if you're writing an essay to say, oh, now that I have this fact, let me explain to you why I didn't answer that way before.
We have just about reached the top of the hour, which means unfortunately the webinar needs to conclude. I know that there are still questions unanswered. I know that the panelists will be sending their slides, at least in a PDF version, to AALS. AALS will send the slides and a recording out to those folks that signed on to the call today. I thank you, presenters, for taking the time to prepare and present today. An informative presentation. I've been taking notes throughout of ways that I plan to adapt and adjust the way that I'm doing formative assessments in my classes around the NextGen Bar Exam. Thanks all, and have a great rest of the day.
Thanks, Jeff and Kelly.
Thanks, guys.